Okay, so we are live now
All
on
right.
Facebook. So anybody who's out there watching this live video, welcome to the estate planning workshop. I'm Melody Bailey with West Virginia It Takes a Village, and I'm here to introduce our speaker today. Brent van Deysen is with Van Deysen Law Firm, and going to be talking to us today about estate planning and all the legalities and financials and all that important stuff that goes along with it. Is that right, Brent?
That's right.
So with no further ado, I'm going to give it over to you because those are things that I know very little about and probably need to know a whole lot more.
All right. Well, hopefully I'll teach you a little something too while we're at it. So welcome everybody. Thanks for joining with us. I'm Brent van Deysen. My specialty in law is elder law and estate planning. So we do estate planning, wills, powers of attorney, living trusts. The idea with estate planning is you want to leave a legacy, and you want to do that in a manner that is that's not going to. I'm sorry, I forgot to lock my front door, and there shouldn't be anybody coming in. Excuse me 1 second.
I'll talk to take up some time, Brent. So this is part of the joy of doing things on a Facebook Live. We never know exactly what's going to happen and what's going to pop up. So I guess Brent is at his home, and this is fun. But yeah, I do think you'll get a lot out of this presentation. I've seen Brent do this before, and I think every time I see it, I learn something new. There's a lot. So if you have a pen and a paper handy, go ahead and grab it. I think that I can see comments as you're posting them. I think that I can. I'm not sure. So we'll have, if you guys have any comments or questions while Brent is talking, just feel free to throw them out there. I'll relay them to him, and he can answer if appropriate or at the appropriate time.
All right, that's the man who takes care of my building. All right, so so when we're talking about estate planning, we're talking about leaving a legacy. So the legacy of stuff that you may have, maybe you've been entrusted with, that piece of family furniture that's been handed down from one generation to the next and was brought here by an ancestor who immigrated from another country. Or maybe you've inherited the family farm, and it's up to you to pass it on to the next generation. These are ideals when we're talking about planning an estate, but really it's going to come down to some careful thinking, some planning, some discerning, and really the right set of documents. It doesn't have to be complicated either. I'm all in favor of simple. So the materials that if you were meeting with me live, you would now have in your hand, as Melody said, we'll be able to get those to you. And please read through those. I've provided a lot of detail because I want to make sure everybody has the information they need to be able to make these important decisions. But when it comes to estate planning, legal documents are very important. In fact, most people think, oh, I need a last will and testament, and that's a great idea to have one. That is certainly the centerpiece of any estate plan. But estate planning needs to consider more than just your death. Estate planning needs to consider that you may go through a period of dramatic illness, injury, or incapacity during your last weeks, months, or years. And so you need to have powers of attorney documents in place. There's one for medical decisions, there's one for financial decisions. So the three documents that everybody should have at a minimum: last will and testament, which allows you to say who's going to receive the money, the stuff, the things that you have, the property that you have. The medical power of attorney, so that you've named somebody to make healthcare decisions for you when you can't. And then a durable power of attorney, which is a legal document that gives somebody the ability to handle your financial and legal affairs for you and effectively be able to sign your name to get access to, your financial accounts, pay your bills, do anything of a financial or legal nature to help you. So when you're planning your estate, there's a couple of really important things to focus on. One, when you're gone, you can have the best written will in the world, but if you've named somebody who can't complete their task as executor, you've created a whole lot of problems. So picking a good executor for your will, for your estate, that's important. So when you make a last will and testament, you're going to pick the person who will handle the wrapping up of your affairs, so to speak, gathering your assets, inventorying them, making sure your final taxes and expenses have been paid. And after everything's been paid, then distributing those assets to make sure they get to the rightful beneficiaries. That's a lot of responsibility. So picking an executor, you want to pick somebody who's good at getting things done. Somebody who's good at getting things done, if they can balance a checkbook, and that's great. Those two skills together, I think you can have somebody who will make a good executor. Now, you also want to pick somebody who, if there's the possibility of conflict between your beneficiaries, you want to pick somebody who's good at resolving conflict or helping to diminish those conflicts. If you've got 3 children and the oldest and the youngest have always been at odds at each other and always fighting and fussing and are always going to be that way, but the sister in the middle is kind of the one who gets along with both, and even at times when they're both been fighting with each other, she can step right in and calm them right down, and has a good relationship with both the oldest and the youngest. That's probably who you would want as the executor. Don't put all 3 of them on as the executor, because then the oldest and the youngest, who've been at odds with each other their whole life, will try to use your death in the process of settling your estate to start World War III. It's unfortunate, it happens. So picking a good executor, one who can get things done, one who won't stir the pot, very important. Realizing too about your beneficiaries and any concerns you might have. Inheritance can be a great thing. You're leaving on property, money. These are things that you've worked for, that you've been able to keep, and at the end, you've got something to show for it to pass on to others. That's often a blessing. But for many people, that could prove to be a curse. If you have a loved one who you plan to leave an inheritance to, and they've had a lifelong of chronic substance abuse addictions, and it often takes the form of ebbs and flows, I guess you would say, where the addiction takes hold. There's a finally gets to a point where treatment is sought. There's a great period of sobriety, and sadly, it seems like the person falls right back into addiction, and it's a cycle. And it's often it's very common to have just personal use, and being addictions in this area can often, doesn't necessarily mean that they're going to be unemployed or unemployable, but it's going to mean that they're going to have the sporadic ability to work and earn a living. And maybe you've been the rock to them throughout all their lives. You haven't abandoned them, even in the worst times. And you've been there to see their rise and their fall again, and then their rise. Well, your death and the rock being gone, combined with a little bit of money, might be the worst combination to turn a lifelong chronic addiction into something terrible, maybe even life-ending. So it's a good time to take stock of any personal problems that your beneficiaries have and consider, will an inheritance make their troubles worse? For example, you might have a child who has a heart of gold, who freely gives of herself or himself, as well as all that they bring in, and seemingly never do anything for themselves. It's not uncommon for somebody like that to attract somebody who's looking to use them for financial gain. I've even had some clients report to me that their son or daughter-in-law will flat out say, although it tends to be more son-in-laws that will do this, will flat out say, yeah, I'm just hanging around long enough until you die and I can, get your inheritance off of my wife. Brazen. So, if you have somebody who's acting like a predator in their life, who's maybe going to take advantage of them after you're gone, maybe you're going to want to structure your inheritance to them in such a way that they don't have free access to it for their own good. Maybe you have a loved one who has a severe disability and receives SSI and Medicaid benefits. Those benefits limit asset ownership to a home, a car, personal belongings, and $2,000. If you gave them even a small inheritance, they would lose those benefits that they so greatly need. These are three situations that you might want to consider in your estate plan, setting up a trust that forms the legal structure to own assets for a beneficiary's use and enjoyment, but then appoint somebody known as a trustee to be a manager of those assets so that they're used to buy goods and services for the beneficiary without necessarily putting a pile of money in their hands, and making sure that if there are unreasonable requests made, that those requests go unfulfilled and be the voice of reason. So taking stock of who your beneficiaries are and their and any fragile personality issues that they might have that may mean that, hey, they should not, for their own protection, receive a direct inheritance. So when you're creating an estate plan, you also, as I mentioned, need to consider planning for a serious disability. Power of attorney documents. That's how you name who will make healthcare decisions and handle your finances for you if you suddenly had a stroke and could no longer communicate, or you had a bad car wreck and you're in a coma for months on end. Somebody needs to pay your bills, or you've developed dementia and nobody realized it at first until one day you're found wandering out in the middle of the road and don't know where your home is or who your closest family are. Having these documents done in advance, put away in a safe location so that if there is a sudden debilitating event and somebody needs to step in and handle your finances, you've already named that trustworthy person and you've created the legal documents to do that. Now, if you have not created those legal documents and that situation arises, if you have a stroke and you can no longer communicate, somebody's going to need to step in and pay your bills, make healthcare decisions for you. Well, when it comes to the paying bill aspect of it, if you haven't created a durable power of attorney in advance, then the only alternative is for a court proceeding to be brought called guardianship and conservatorship, and for the court to appoint somebody to manage your affairs then under court supervision, possibly for the rest of your life, certainly for so long as the debilitating conditions exist. Now, wouldn't you rather be in control of who that person is? You might have a trustworthy friend who's going to be the best person to serve in that role, as opposed to one of your children, albeit they might be well-intentioned, but they moved out to the West Coast decades ago and don't really know that much about you in your late adulthood anymore. And while they would be willing and capable of providing some level of management and decision-making authority, having somebody who knows you well to step into those roles is important. Now, if you don't have anybody that you trust to put into that role and this situation befalls you, then the county sheriff is tasked with the responsibility of handling your financial affairs after a court proceeding has been begun to have you declared incompetent. If there's nobody to make healthcare decisions for you, then the local DHHR office, Adult Protective Services, will make those decisions for you and can be appointed as your guardian as well. So for those of you who are already concerned about too much government intrusion in your life, here's a great way to avoid unnecessary intrusion, particularly where you have a trustworthy family member or friend that you can name to make these very important decisions for you if the circumstances come up that they need to be made. Now, estate planning often includes creating a trust. I talked a little bit about creating a trust, which is a legal agreement that would allow for the management of assets for somebody other than yourself after your death. It's not too uncommon. If you're going to leave an inheritance to a young person, a child or grandchild, for example, if they're under age 18, they can't legally own anything. Temporarily, their guardian would be the custodian, or meaning the keeper of that asset. But once they turned 18, woohoo, it's all theirs. I would not have been a good person at 18 to have had an inheritance. Age 25 is a whole lot better. So, if young people are in your estate plan, you can create a trust that they won't have free unlimited access to the inheritance until a certain age. I think at a minimum that should be 25, maybe 21. If you're making this and the young person's already 18 and you can see that they're very responsible, good at getting things done, good at handling their own funds, then an inheritance at a young age may not be such a bad thing. But we set something up like this to put, at least a date where we're hoping that they're going to, mature. I think they say that by age 25, the brain is fully developed. So, decision-making capability should be there, although there's always room for improvement and wisdom. So by creating a trust for beneficiaries, you're putting somebody in charge as essentially a manager of those funds to make sure that their inheritance is used wisely for them and to some extent preserved for the future. Now, trusts might also be created for assets that you own. That's referred to as a living trust. A trust agreement that would hold assets, and instead of your home or savings or annuity or mutual funds, instead of them being owned in your individual name, you might set up a family trust to become the owner of those. There's many reasons to do that. One is to minimize exposure to probate, although probate in West Virginia is not the big deal that it is in states like Florida or Ohio, where it's very common for people to set up living trusts just to avoid probate there. Probate here in our states, pretty basic, pretty easy. Many people can do it on their own. It's not a formal court proceeding. It's more of an informal court proceeding through the county commission and county clerk's office. Living trusts, I set up a lot of living trusts for people who want to protect assets in case down the road they wind up needing nursing home care. If we have time in our segment towards the end, I'll talk about some of the things you can do to shelter assets for nursing home care as well. So then probate, what is probate? So probate is the legal process through which there is government supervision of the retitling of certain assets that you own into new beneficiaries and government supervision of your estate to ensure that anyone you owe money to gets paid first, including government agencies for any unpaid taxes. So the probate process is guided by a last will and testament. That's the document you can make to say who gets what from your stuff. And the typical way that this process begins at your death would be for the person who's named as the executor to find your original will that you signed years before, take it to the county clerk's office along with a death certificate. And doing that, the county clerk will then appoint the person as the executor, give them their official letter from the county with their embossed seal on it, giving them the authority to then have access to assets belonging to the person who's passed away. This authority then extends not necessarily to every asset owned by the decedent, and that's an important distinction. So if you have a retirement account or you have a life insurance policy, when you set those up, you named a beneficiary to receive that payment direct at your death. It's called a pay on death beneficiary designation. It's very efficient. Well, that beneficiary designation takes control over what your last will and testament says. So if you've created a will later in life that says, I leave all of my estate to my 3 children in equal shares, but 30 years earlier when you didn't have children and you created a retirement account and a life insurance policy with your employer, you named your sister as the pay on death beneficiary. Well, at your death, if you haven't changed those beneficiary designations, it doesn't matter that you've made a will leaving everything to all 3 kids. The retirement account and the life insurance policy are going to go to your sister. So when you're creating an estate plan, it's more than just creating the last will and testament. You have to do an inventory of your assets and look to see, are there beneficiary designations that are already in place that are different from what I want? If so, you need to change those. If you don't know or don't remember what you put down, you need to check and make sure you update those. You know, it's not uncommon for many people to have the bulk of their savings in an IRA, and that IRA is going to have a beneficiary designation from when you created it, however many years ago that was. So if you create that will and it doesn't match, or if the beneficiary designation doesn't match or doesn't do what you want, you know, you've effectively not gotten what you wanted for those assets at your death. So the probate process does not deal with assets that are payable on death to others, that are governed by the account agreement. So with life insurance or retirement account. Now, if your life insurance policy didn't have a named beneficiary, then it's going to be paid to your estate. And now, yes, it's part of the probate process. If you own real estate jointly with somebody else, take a look at the deed. If it includes the phrase with right of survivorship, then whoever dies first, the survivor is going to take ownership. So for example, your parents give you and your sister the family farm. In West Virginia, your parents could create a deed, name you and your sister as the joint owners of that property. You would never even have to sign the deed. Your parents can sign it themselves. You may not even realize that they even created this deed. You may have thought, oh, I inherited the family farm with my sister through the will, because you've never gone to check at the courthouse. And so in your later years, you create a will that says, okay, when I die, I want to give my half ownership of the farm to my son. At your death, your sister survives you. Your son, who is expecting to be a half owner of the farm, is then told, oh, by the way, no, your aunt here inherited the whole thing here when your mother died, because our parents put a survivorship clause in the deed. That means whoever dies last gets the property. And I don't like you. I'm not going to include you. I'm just going to include my own children. See how terrible that could be? So knowing how you own title to assets, if there are joint owners, it's important. Now, in that example, mom and dad who created the deed could have chose not to put in the survivorship clause so that the sisters could have each designated who would get their half ownership. The same is true with bank accounts. You know, mom has 3 kids. She puts her oldest daughter onto the account, not realizing that the bank made her daughter a joint owner with survivorship rights. Mom dies, she has a will that says everything goes to all three kids, but the oldest daughter, who knows a thing or two about the law from all her internet readings, says, this account belongs just to me, not to you two, so I'm keeping it and I can legally keep it because mom named me the surviving owner. If she was a nice person, she could say, oh, well, mom didn't really intend me to get all this money. I'll share it with you. But she wouldn't have to. So not only verifying the pay on death beneficiaries, verify if there's joint ownership with survivorship rights, because you don't want to be surprised. Melody, if you're asking me a question, I couldn't hear you.
Can I ask you a question about that?
Yes.
So you talk about the situation where the inheritant decides that they don't want to be the sole owner and they want to share it. Is there a legal process that they have to go through to make that happen? Or can they just say, this is what I'm going to do?
Sure. So if the one daughter received $30,000 in a checking account that she was co-owners with mom on, and there's two other siblings, and she wants to give, let's split that account three ways. I'm going to give $10,000 to one of my siblings, $10,000 to the other. I'll keep $10,000 for myself. Well, the one who received the $30,000, she has now made a gift of $10,000 each to her other siblings. That gift is under $15,000 in the current tax year. So there's no reporting requirement to the IRS. Now, if it was more than that to one person, you have to report the gift, but you've got an $11 million credit against any possible tax. So it's a reporting obligation if you give more than $15,000 to somebody in a year, but you can avoid the tax by reporting it.
So a reporting obligation, but not necessarily a tax obligation.
Exactly. Because when you report it, then you apply the gift to your $11 million credit so you don't have to pay tax. That's the right way to do it. Many people don't even realize that's an issue and make a gift, don't report it. Nothing comes of it, but it's, you want to do it the right way and report it in case there was ever an IRS audit. You're good. And why not report it? There's no tax implications by reporting it. Unless you got more than $11 million laying around. None of my clients have more than 11.
Yeah, that's probably a discussion for a different topic.
They're looking for a different attorney if they've got they want the one with the skyscraper and the $1,000 suit. That's not me. Okay. All right. So the probate process then continues on. When the executor applies, gather up the assets, report the assets in an inventory form so that beneficiaries know what's there. Then the county clerk's office advertises the estate, and that gives creditors an opportunity, a 60-day period of time, that if they want paid, they need to make a claim. If they don't make the claim, and if the executor is unaware of the claim and they close the estate, that creditor is going to have a very hard time trying to collect against the beneficiary. I mean, it's conceivable that they could do that for up to a year. However, by that point, it's very expensive and burdensome for the creditor. So for all intents and purposes, if a creditor fails to make a claim within that 60-day window of time, they're likely not going to pursue it because of the complexities and costs involved, assuming it's just, a typical couple $1,000s, couple $100s. So once claims have been made and paid, the estate is advertised one more time to make sure there's no objections, and then assets can be distributed after the closure of the estate has been approved. Now, if you don't have a will and at your death, you'll be happy to know that the state legislature has created a will for you. Now, you may not want what our state government is going to give you for a will, but it may not be that bad. If you have a traditional family setting. So if you die without a will and you're married and have no children, then what you would expect happens. Everything goes to your surviving spouse. If you don't have a surviving spouse, but you have surviving children, those children would take. If you have a surviving spouse and you have surviving children, but those children are not of this marriage, then assets that go through the probate process go 1/2 to your children from the previous relationship and 1/2 to your surviving spouse. Now, that doesn't cover assets subject to a pay on death beneficiary designation. So if at my death, if I'm married, I have children from a previous relationship, but the only thing I own is a life insurance policy and a retirement account, and I've made those payable on death 100% to my spouse, well, there's nothing that my children from a previous relationship would be able to get. Blended family situations cry out to have a last will and testament, to have an estate plan. Because in the scenario that I've described, if the later in life marriage, if the husband owned a home solely in his name, brought that into the marriage, and over the next 20 years, him and his wife, put her money into his house. He never put her on the deed. He never made a will that named her as a beneficiary. If he dies first, she's now going to co-own his house with his kids, who maybe haven't talked to him since he got divorced, maybe have never met her. But I bet one thing's for sure, they'd want their half of the value of that home that she put all of her separate money into. You see the problem with that? So blended family situations, there are a lot of really great blended families out there. I'm blessed I'm from a blended family where things are great. We have a loving relationship. I have a blended family and things are great. We all have a loving relationship. So having an estate plan can be a great gift to your blended family to help keep the peace and make sure that expectations are met. Not having a will in a blended family is unfortunately fairly common because, and it seems like I see this more with men, maybe that's just my observation, seems like they have a hard time coming to grips with the fact that they're not going to be able to please everybody. Maybe the children from a previous relationship rightfully believe, hey, Dad, if you don't give me a little bit of something of what you got, your wife just doesn't like me. She's going to give it all to her daughter. Father may very well agree with that, but instead of doing something about it, he doesn't face the issue. Because what is he going to do? Make a will and then tell his wife who he loves and who he's married to? Oh, by the way, I chose not to leave part of what I own separately to you because, well, I don't trust that you won't just give it all to your daughter and cut out my sons. There's a great fight buried in all of that. And so unfortunately, what I commonly see, and I don't know why, I'm sure it's just as equally between women as well, but I seem to have in my memory a lot of men who have failed to confront these issues. And maybe that's because it seems like children are more often to be estranged from a father in a divorce setting. And so he's got to reconcile with all that as well. The point I want to make is in a blended family situation, you really owe it to yourself to have a last will and testament. If if you're a procrastinator and, if you just don't feel like doing any of this, if you do want to do something, the bare minimum, other than doing nothing, do a durable power of attorney that names somebody to handle your financial and legal affairs. If you don't create a medical power of attorney, we have something called the Healthcare Surrogate Act that allows a physician to pick who would make healthcare decisions for you in that setting. And that's better than nothing. If you die without a will, our state legislature's created one. You've probably got life insurance and a retirement account that's going to go to a named beneficiary anyways. But if you don't have a durable power of attorney and you have a stroke, there's nobody that can access your retirement account if you're still living. It's only owned by you. That means that somebody's having to go to court, and then is there going to suddenly be a battle for who that's going to be? Yeah, hopefully you've got people fighting to take on that responsibility. Maybe you've got people fighting to get access to clean you out. So having that one document is very important. If you're of the mind to not do anything, at least do a general durable power of attorney. Okay, so that's about as much as I have to say about estate planning and the probate process, and in general about trusts. And just to recap, the 3 basic documents that everybody should have in their estate plan: last will and testament, medical power of attorney, durable power of attorney for finances. Those are the 3 simple things that if you want to give a gift of simplicity after your death, if there is such a thing, that's at least a way to put your beneficiaries and heirs on the track to have an easier time resolving your affairs. All right, so let's talk now about the topic of nursing homes and how to protect assets. Melody, how much time did we schedule this?
We have another 23 minutes to go.
Okay, another 23.
Can I roll back to the previous topic really quickly and just ask a quick question? If someone doesn't have these 3 documents, how can they get them? Is this something you can create on your own? Do you have to have a lawyer? Does it have to be filed with the court?
Sure. So you can create a medical power of attorney through any hospital. They're going to have those documents available for you. With online programs like LegalZoom, it is conceivable you can go online and create a last will and testament. You can create a durable power of attorney. When it comes to, as a professional, as an attorney, creating these estate planning documents for my clients, I've got 20 years experience of being an estate planning attorney. I know what a lot of the issues are that are underlying this. And it's real easy to think, I just go online, plug some names in, and I've got a will. Well, and some of those wills turn out to be just fine. But it's being prompted to look into other areas that you may not know you don't know. That's really, it's what you don't know you don't know. That's the thing to be worried about. You may write up a new will and nobody ever suggested to you, go check your beneficiary designations. Or, maybe that will doesn't completely give away everything because of the way it's worded. I've seen that at least, I'd say probably at least 4 times in the past 2 years, where an online or an office forms will says, okay, I give my jewelry to this person, I give my car to this person, I give my money to this person. But then it doesn't say anything about the rest of the stuff. So you've got part of an estate that doesn't go according to the will, and what a mess. If it's worth doing, it's worth doing right. Creating a last will and testament, many people fit my plan for a simple estate. The basic simple estate will is $300 through an attorney's office, and sure, there's lots of attorneys who do wills. If you come to me to do a will, I make it a priority. You get an appointment to come back when the documents are done and ready to sign. And I've helped walk through with you all the pros and cons and all the things to look out for. It's just, in my opinion, I think it's well worth it.
I agree. I think your expertise is very valuable in that case.
Yes, and to understand, certainly you have people who have had bad experiences with messy estates because they had loved ones who left them an inheritance, and what a mess. People like that can often appreciate and often go to attorneys because they want the best chance to provide a smooth transition. A lot of people just don't understand what the issues are. And, I'm all in favor of trying to do things yourself when it's completely possible. And I think doing a medical power of attorney on your own using the form that's available through the hospitals, I think that's a very safe thing to take on by yourself. Okay, so let's talk about Medicaid and nursing home settings. So in West Virginia, we have the Medicaid program, which will pay for a lifetime of nursing home care if you financially qualify. Medicare and your health insurance will only pay for skilled care after a hospital admission. Physical therapy after a fall or a fracture, that's very common. Typically up to 100 days of inpatient physical therapy, maybe shorter if you're no longer benefiting at some point. That's as much as your health insurance and your Medicare is going to pay. So Medicaid is for the long term. Medicaid will pay for a lifetime of nursing home care once you financially qualify. But to qualify, there are certain assets that you can own that they don't look at the value of. They don't put a value on them. That would be your home, one automobile, your household goods, personal belongings, your home, and all adjoining land. They don't put a value on that, meaning they don't count it. It's exempt. Well, as long as its value is less than $585,000, but we don't have to worry about that in our state. We don't all have $500,000 houses, do we? I know I don't. So you could own a home, a car, household goods, go into a nursing home and qualify for Medicaid as long as you don't have but $2,000 worth of other assets. So what if you do have more than $2,000 worth of other assets? What if you've got $100,000 in a savings account or retirement account or combination of both? What happens? Well, you go into a nursing home and you've got $100,000 worth of financial assets. The Medicaid program doesn't say, oh, we'll take that and pay for your nursing home care and only hope you live 60 days. No, it doesn't work that way. The Medicaid program would simply say, you're not eligible. Go spend down is the term. Spend down the $100,000. And after you're done spending it, come back and reapply. So that's what you do to qualify. You'd be a private pay patient paying whatever the nursing home charges, whether that's, in Kanawha County, the highest nursing homes, about $14,000 a month just for room and board. The average is probably 10 to 11. I imagine there's some that are still at charging $8,000 to $8,500, but those would be very, very few and far between. It's really expensive. So spending excess assets is how you qualify. You can't just give away your assets to your kids or your favorite church or charity and then expect the Medicaid program to pay for it. If you did, you wouldn't qualify for a period of time. So if you had $100,000 in cash and you decided, I'm going to go in the nursing home tomorrow, I'm going to give this away to my daughter, and show up at the nursing home and ask for Medicaid to pay. If you give away $100,000, it's 10 months. The Medicaid program will not pay for your care when you're unable to pay for it yourself. So you qualify by spending. And so if you're at the nursing home and it's $10,000 a month and you go in with $100,000, you could conceivably $10,000 a month at the time by month 10, you've spent it all. But there's no requirement that you spend all of your money paying for care. We can come up with a plan to help you spend that money in better ways. So for example, if you've got $100,000 and you're about to go into a nursing home and you have some debts, well, let's spend some of that money paying off debts. Maybe you've got a home equity loan or a mortgage against your home. And if you got $100,000 you owe on the mortgage and you got $100,000 in the bank, don't spend the $100,000 paying for nursing home care and be stuck with a mortgage you can't pay. Pay off the mortgage. Then you can qualify for Medicaid that much sooner. Car loan, student loan, as long as you're a co-borrower or co-guarantor, if you pay off your grandchildren's student loans, but you're not legally responsible to pay them off, that's a gift. You don't want to do that. So spending money paying off debts. You're allowed to own a home. They don't make you sell it in West Virginia if you go into a nursing home. So if your home has the need for some repairs or improvements, and there's a chance you might get well enough, 10 months down the line, why not spend some of your money taking care of those deferred maintenance items with your home? So, hey, if 10 months from now you got well enough to go back home, you'd be going home to an empty bank account because you had qualified for Medicaid, but at least your home would be renovated. Be a lot better than going home with an empty bank account and a home that needs a new furnace and carpet and windows and all that.
Maybe a good time to spend some money on home improvements that help you maintain a safer lifestyle in your home.
Exactly.
Chairs and ramps, accessibility things.
Take out the bathtub, put in the shower. Very good things to do. You can have one automobile and the value doesn't matter. So, if you got an old worn out car and you're questioning, maybe you'll never drive again, maybe you will. And the choice is spend a bunch of money paying for nursing home care or sell your old car and get a good new or good used one. So if you do get back out, you've got that to drive. Or if you have a spouse at home, you're giving him or her a better car to drive. And there's no limit. If you've always wanted that 1-ton Dodge Dually with all the bells and whistles and leather and diesel makes all the noise, hey, $80,000 as long as it's going to be used for basic transportation. So spending money on your home improvements, paying off debts, buying a different primary automobile, those are all easy ways to spend excess money. Prepaying funeral or cremation costs, also a good thing to do. So if spending isn't something that you have an inclination to do, maybe you've got $100,000 and you're married and you have a spouse at home. Well, gosh, if I spend all $100,000, she's going to be left with nothing. She's going to be broke. Well, the Medicaid rules allow the spouse at home to keep the home, one automobile, household goods, and 1/2 of the value of the rest of the assets. So if the total assets are $100,000 plus the home, the car, and the furnishings, the spouse at home can keep $50,000. That means instead of spending all 100, just got to spend 50. And so, hey, maybe her and you both got two 10-year-old cars that are, still getting by, but are near about worn out. She only needs one car. You're not going to be driving. Let's go spend that $50,000 and maybe get a new SUV for her, sell your other two cars. Or, if the cars are fine, but she's always wanted, that real nice designer kitchen. Now's the time to spend it if that's her sort of thing. Or maybe making the home more accessible for her as she ages because she's in better health than you, but that may not always be the case. There's some other options too. I don't have time to get into it, but for example, in our married couple case, the $50,000 that needs to be spent to qualify, the wife at home gets to keep 50. The other 50 she has to spend. Well, instead of spending it on care, spending it on a new car or home improvements, she can put it into a short-term annuity that's going to pay that money to her over a period of time. And basically, she's going to park her money in an annuity for a couple of months. Her husband's going to qualify for Medicaid. And that annuity is going to pay her back that money. Pretty neat stuff. Another option that we sometimes use for a single person. Let's say the parent's gone into the nursing home. They're single. They've got 2 kids. They've got $50,000. They don't have anything they want or need to spend the money on, but they want to be able to leave an inheritance. They can get a guaranteed issue group life policy that's basically, if they've got $50,000 to spend, they're going to buy $50,000 worth of death benefit coverage that will pay out at their death, but over a 5-year period of time. Now, the annuity that I've mentioned, this life insurance policy I've mentioned, I don't sell financial products. I'm an attorney. These are unique financial products that have been created for use just for folks who are trying to qualify for Medicaid, and instead of spending their assets, want to do something to either save monies for their spouse or save monies for their kids or other people. You wouldn't want to just ordinarily go out and buy a life policy or an annuity like this, because they're really designed for somebody who has no options other than to do this. But if the choice is let's lock away $50,000 in a life insurance policy until I'm gone, knowing that over a 5-year period of time that'll pay out in equal payments to my kids, that's probably a better option than just spending it paying for nursing home care. From a consumer perspective, when you consider too, in West Virginia, there's only one nursing home that doesn't take Medicaid that I'm aware of. They all take it. There's no difference in our state from one care setting to the other. If you've been to a nursing home, you can't tell who's receiving Medicaid, who's receiving Medicare. Now, Medicaid won't pay for a private room, although some nursing homes, as they're being renovated, the baby boomers are a little bit more particular about their privacy, and some nursing homes are choosing to even offer private rooms for somebody on Medicaid. So that's kind of facility by facility basis. Other than that, it's pretty much the same care. Now, the question I get time and time again, if I go into a nursing home, is the state going to take my home? No. In West Virginia, if you go to a West Virginia nursing home and qualify for West Virginia Medicaid, our state does not make you sell your home, turn it into a pile of money, and then spend that money on care. However, if at your death, if there's no surviving spouse and nobody else co-owns the property with you or takes the property through your deed, then the state has the right to go against the home and recover costs paid for under the Medicaid program. So if the state paid for your care to the tune of $200,000 at your death, if you have a will that says I leave my home to my 3 kids, and you're the last owner on the deed, state files their claim for $200,000, the property is sold, brings less than $200,000, guess who gets all the money? State of West Virginia. So the great news in West Virginia is our legislature gave us the legal tools to help you change all of that. There's a couple of different things we can do. The most practical last minute planning option is what's commonly referred to as a deed on death, where you're going to name who you want to take ownership of your home through your deed instead of through your will. That deed doesn't take effect until you die. So if you want your children to receive your home at your death, you create a deed on death, you name the kids. If you go into a nursing home, and you don't have to sell your home when you go in, at your death, if you still own the home, your kids take ownership of the home through that deed, and the state legally loses their right to go against the home and recover the Medicaid costs. To me, that's a pretty great gift for last minute planning. The 5-year look back doesn't matter for that. And as a practical matter, you're not giving up ownership of the property to your children while you're living. You still own it 100%. You could sell your home, you could borrow against it. You could later change your mind and decided, okay, I don't want to leave it to all 3 kids. I'm just going to give it to my grandkids because, well, they always loved me, and my children didn't come around and do things I needed to do to care for me. Typical gripes I hear. So there's also, and I don't have time to get into this, but for people who, maybe have more than just their home, maybe they've also got the family farm, or they've got rental property, or they've got a hunting camp or a beach condo at Myrtle, or they've got money in mutual funds or annuities or CDs or savings or stocks, and really don't think that they're going to want to turn that into cash during their lifetime, but are worried that they might be forced to sell those properties or liquidate those investments because they went into a nursing home and had to spend through that. We often set up a living trust. I call it an asset protection trust. That's the name I call it because that's what it does. This type of trust agreement is a living trust, meaning, if you're John Smith or if you're John and Mary Smith, married couple, we create the Smith Family Trust. We change the deeds to all the property. So your family trust is the owner. You have the right to use those properties and live there. If they're rental properties, you have the right to receive the rental payments. If they're vacation properties, you have the right to use them. But the state doesn't have the right to go against your home. And if they're properties other than your home, you can't own properties other than your home if you go into a nursing home because you're limited to $2,000. So if you've got, if you own your own home in town, but you've also owned the family farm, let's put that into an asset protection trust so it's not forced to be sold and the money spent on nursing home care when Medicaid's available, or you've got a hunting camp or a beach condo or rental properties, you want to pass that on as an inheritance. You don't want to be forced to have to sell those. Let's go ahead and set up an asset protection trust as a way to shelter those. You have to be in fairly good health because there's a 5-year look back. So, at least a 5-year period of time where you're not expecting to apply for Medicaid in a nursing home setting. That's the key there. And I think that takes us to about 3 minutes before the end. Do you have, are there any other questions that have come in, Melody?
I don't see any in the chat, but if anybody has any questions and you want to throw them into the comments, then now would be the time.
Yeah, and my website is a great resource. That's wvelderlaw.com. WV like West Virginia, elder like old, law.com. wvelderlaw.com. I've got some videos on that. I've got a lot of information that we've talked about. I do seminars around the community. I've got one coming up. It's either downtown Charleston or South Charleston on the 22nd of October. You can find the link to that on my website. If you'd like to learn more, if you'd like to come see me in person, I've been doing free in-person seminars now for 12 years. I try to do probably 8 to 12 per year. Of course, with COVID so far this year, I've only done 3 live ones. But I like the live seminars. I think people get a great benefit out of being in person, although Zoom makes things pretty handy and Facebook makes things pretty handy to do things like this too, but maybe that's not such a good idea.
I do think that you are also giving a similar presentation tomorrow, if I'm not mistaken, with Kanawha County Public Library on Facebook.
Yes, through Kanawha County Public Library, Facebook. It'll probably be just kind of a repeat of what we've talked. You probably noticed I didn't look down at my materials. I know this stuff pretty cold. So this is pretty much coming off the top of my head from my knowledge. So if you do tune in tomorrow, it'll probably be pretty much the same thing. But my seminars in person, I get into a little bit more in depth than I think we have tonight.
And tomorrow may be a good option if we have questions that kind of pop up in our minds between now and tomorrow, we can think about it and
that's right.
Come to the seminar and bring them.
Yep, come to the seminar and bring them. And if you come to the in-person seminar, those are usually pretty well attended. But I hang around after the seminar and answer as many questions as you want. Some of the things I do that are unique. You can hire me to go through the nursing home Medicaid process And then I deal with the DHHR on your Medicaid application. I'm giving you all of the advice on lawful legal ways to spend assets. We don't hide assets. Hiding assets is illegal. We're using the positive provisions of the law that give you, the consumer, a benefit. So it's all legal. We also do wills and powers of attorney. And true, there are other attorneys that do those. Some of them do them quite well. A lot of them don't give a priority to your will. And so 6 months later, you're calling for the third time, begging for an appointment, and they haven't made you a priority yet. That doesn't happen here. If you come to see me for a will or a power of attorney, you're scheduled for a signing date when you can expect your documents are done and ready and all ready to sign.
We have a question about phone number. Can people contact you via phone? What's your phone number there at the office?
In Charleston, it's 304-343-3777. I also have a full-time office in Morgantown. The number there is 304-594-1900. Both offices are full-time, so if you walk in 5 days a week, you will find my very well-worked employees. I'm the only attorney. I see clients in my Charleston office on Thursday and Friday, in my Morgantown office Monday and Tuesday, and I've been an attorney for 20 years. I've had my Morgantown office, it'll be 12 years here in January, and in February, it'll be 8 years for my Charleston office. And pick an attorney who might be a little younger than you. I just turned 50. I plan another 18 to 20 years because I've got a 6-year-old. There's no way that that I'm going to be able to retire at a young age. I'll be working at least till I'm 68 or 70. So for you procrastinators out there that like to wait, if the Lord gives you time to wait, come see me when you're ready.
Thank you so much, Brent, for all this information. I really appreciate it. It's been awesome. Every time I see you present, I feel like I picked something up, something that I missed before. So I appreciate it.
Well, I'm glad for that.
With that being said, I think we are done for the evening. So we'll probably tune in and see you at some other point. Thank you so much.
Okay, thank you.